Mr. Nariman, Vice President, Bar Association of India, Mr. Vikramjit Banerjee, Additional Solicitor General, Mr. V.B. Acharya, Senior Advocate, Mr. Kumar Akash Pandey, Assistant Professor, Mr. Srinivas, Advocate, Mr. Nitin Thakkar, Senior Advocate, all other senior advocates over here, legal luminaries, jurists, academicians, and my young friends. Good morning to all of you, and thank you for inviting me to express my views on these three new enactments which are to come into force on the 1st of July 2024. Undoubtedly, law is the embodiment of societal demand and it evolves as per the need of society. And efficiency of any law depends on three factors. Firstly, how the legislature legislates it. Secondly, how the judiciary interprets it. And thirdly, how the executive implements it. Now, in fact, these enactments are required to answer all these three stages. But what we find is 90% of the provisions are verbatim the same as the earlier enactments, except instead of the section now we say it's a clause. They have been rearranged, so we'll just keep comparing which was the earlier and which is the old, and we'll say instead of section we'll now start saying clause. Like if cheating there were 5 offenses, we will instead of saying 420, 421 and all, they're all clubbed in one subsection, one subclause 1, subclause 2, subclause 3. So these are, in fact, I'm in total agreement with Mr. Acharya that if there could be amendments brought to these three codes, that would have been far more effective. And I thought there was more deliberation required, more thinking required, more exercise required before bringing these 10% of changes which have been there. There is a welcome step in these in BNSS where section 176(3) provides that for any offense which is beyond 7 years, the crime scene collection has to be by the forensic experts. And there is a mandate given that in 5 years all states will have their forensic evidence collection compulsorily. No, by merely providing this does not really help that we'll be able to do forensic evidence. For a state like Delhi, I know at one stage when I was a standing counsel, a writ petition was filed and we ensured that there is a mobile crime team in each district and specially vacuum analyzers, sweepers, etc. were ordered and that they will be investigating. 4 years down the line, one day I had an occasion to see how these mobile crime teams were working and still found that they were collecting the fingerprints by putting the powder and taking it out. So ultimately, unless this comes in the practical domain, this will not help us. Contemporaneously, they have made provisions under section 185 and 105 of the BNSS which provide that the search should be audio videographed. Now it's very essential. There was in fact a demand for a long time because witness may change, but the fact if the videography of the incident is there with the court or the crime scene is there before the court, it really helps. But what was actually required, this otherwise could have been done without an amendment, but what was actually required by the legislator to have done is to deal with the issues of its admissibility, veracity, how to ensure time stamping and all that, which has not at all been answered in these enactments. Today, can you just say anybody using an electronic evidence, Simpliciter gives a 65B certificate, it becomes admissible, and 99.9% there is no inquiry beyond it for the veracity of that document, electronic document, because we don't have that systems in place, we don't have that systems in enactment. And mind you, the technology is progressing very fast. Today, there is a provision in this that the charge sheet, all documents will be supplied electronically. I have dealt with cases at the appellate stage where documents were there in the CD, and when it came for hearing at the appellate stage, we didn't have any computers which could read those CDs. This is how the technology gallops. So these are the actual answers which we need to give. Even without these amendments, audio videography, if it was done, that was admissible. See, what is the scope of investigation? CRPC never defined, and it can never be defined. Because in every case, the fact situation would demand a different way, technique to collect the evidence. You can have some standard facts, some standard, okay, but it all depends on the facts of each case. By defining certain clauses, you do more harm than benefit to those provisions. And what was actually required to be defined as to the efficacy, the veracity of these, and how to deal with these evidence has not been done. Now, I'll just show a practical example. Today, I think mobile phone is the first thing which is asked in any investigation. Now, obviously, there are concerns of right to privacy and right to investigation. That apart, does the answer lie in giving the entire mobile phone to the police investigating agency? Once it is seized, it's seized for the investigation trial, and the person will now have to start up afresh his entire mobile data. Everything goes today. Everybody's data is there in the mobile itself. I remember today they used to seize the CCTVs. So what they would do is take the DVR of the CCTV. Now, none of these enactments answer how to deal with this scientific evidence. I would often ask them, then I made them lay down the guidelines that how can you take away the DVR of a third person who has invested CCTV for his security, because you need in the investigation. Either you give him a substitute DVR, that's a state's responsibility. It is not for that common man to bear the cost of your investigations. We don't have any mechanism. None of the police officers is trained to take the mirror images on the spot. You take the mirror images and work on it. When you asked that what is the investigation done, we seized this instrument. Now it's been sent to forensic. That report will come after 6 months. Then you will get to know whether actually any offense has been committed or not. This is especially so true when the allegations are that they took my morphed photographs or some videos and all, and they have misused it. Now for 6 months you have no material because the police seizes a mobile phone and keeps it in custody and sends it to the FSL. We didn't even open and see, because if they open, then the allegation will be that it is tempered and all. What was required to be answered for electronic evidence was the mechanism to take this evidence, mechanism how to deal with it, how to ensure the efficacy of it, and that there is no tampering with it, which has not at all been answered in this. I am grateful to Mr. Acharya, who said that yes, zero FIR and preliminary investigation. In fact, if you have our old CRPC, which is still functional, it does not tell you where that. It only says under 154, on receipt of an information, the SHO will register the FIR, the information. It does not say that whether the offense took place here or somewhere else. Only when it is an application and filed under section 156(3), it was said that the magistrate under whose local jurisdiction the offense was committed. So the jurisdiction issue came only at the stage of 156(3). Undoubtedly, providing for a preliminary inquiry is incorrect. That's just in the teeth of the decision in Lalita Kumari's case, and giving more powers to the police. But what is more interesting in this 173 BNSS is you can not only register the FIR in another jurisdiction with the permission of the ACP or the DSP, you can investigate, arrest, do everything in your state. So, supposing our country has a federal structure, supposing an offence is committed in Delhi, there may be a dispute between two police stations whether X or Y, but that may not be so material. Imagine an offence committed in Delhi, the complainant goes to a remote part of the country, lodges an FIR, the concerned DSP gives the permission to investigate after preliminary inquiry, and then the person will be tried there. See the consequences of that. That may be actually one of the most challenging issues which we'll have to face after 1st July. Now, undoubtedly, colonial laws had to give way and our national laws should come into place. But let me tell you, there's been serious regressions in this enactment, and more powers to police state. Earlier, if somebody was to be handcuffed, it was required of the police officer to move an application before the magistrate who would give permission. Today, section 43(3) of the BNSS provides a discretion with the police officer to use handcuff while making arrest, keeping in view the nature and gravity of offence, such as habitual offender, one who has escaped, who has committed organized crime, terrorist, drug related, illegal possession of arms, ammunition, murder, rape, POXO, etc. Now, in this thing, I'll just give you an example. Terrorist Act, we know, first we had the TADA, then POTA, now it's UAPA. Now, verbatim, UAPA's Terrorist Act has been brought as section 113 of the BNS, that's equivalent to IPC. Organized crime, which is an offence under the MCOCA, which is extended to Delhi, Maharashtra Control of Crimes Act, extended to Delhi, Gujarat Control of Crimes Act, then AP COCA, some of the states have it, has been now provided as an offence under the IPC under section 111 and section 112, which says petty organized crimes. Now what? You have a special enactment, you have a general enactment. In the special enactments, there were some safeguards in the sense only a senior officer could direct. There were some checks and balances, though the rigors of bail were serious. Now here, once they come in the IPC, any police officer can come and arrest you, register the FIR under organized crime, under the Terrorist Act, and follow the procedure under CRPC, which includes 43(3) BNSS, which including his discretion to handcuff you. Now, more than one charge sheet for an offence of cheating, and a person is at the discretion of the police officer liable to be taken and paraded in handcuffs. So that may be one of the situations. Now, there is a salutary provision 197 CRPC, and repeatedly Supreme Court has said it's not an idle formality. Section 218 of the BNSS provides that if the sanction is not given within 120 days, it will be deemed to have been granted. Now, all the safeguards of the accused under 197, that there was no application of mind or it's by an incompetent authority, is gone, and merely because, and no order means there is a sanction. Firstly, there had to be a positive order. Today, no order of sanction means there is a sanction. Then, coming to the, undoubtedly, as the solicitor said, we have witness protection incorporated. But unless we have a complete mechanism how to grant witness protection, merely by Section 392 mandating preparation and notification of witness protection scheme will not help. See, in other countries there are Witness Protection Act. Witness protection is a very important aspect of a criminal trial. I remember the first time in India witness protection scheme was laid down by the Delhi High Court, given to Neelam Katara in the case of Nitish Katara murder case. That was the first time when they said any person where the police officer feels or the person feels, he will apply. The Legal Services Authority secretary was made the member secretary, who will apply his mind and then grant protection accordingly. Now, merely giving a 392 mandate, prepare, notify, witness protection scheme, that doesn't help, because it is a very varied subject. Protection to witnesses is required at various levels in various forms. It's not merely a police protection. I have dealt with cases where each of the witness had police protection throughout the trial and each one of them turned hostile. So there are ways and means how to deal with it, and this by mere enacting Section 392 CRPC, mandating preparing and notifying witness protection schemes, is, I would say, a lip sympathy. We need to really work on this witness protection, maybe by bringing an act if we have to move forward. Then, just one more thing which I would like to add up, that in these changes which have been brought up, one of the changes which Mr. Acharya said was that you can now have the custody. It is for the first 40 or 60 days that any time police custody can be had further, but for a total of 15 days. Now the pitfall of it is that we will, today once the police custody was over, the accused was said, now whatever you wanted to recover, you can have recovered. I am entitled to bail. That is a valuable right which I don't think which will have to be looked into. There are undoubtedly some good changes, but I thought that those changes need to be worked upon, and as Mr. Acharya said, that we can just we should have worked on them as an amendment, and wherever necessary brought separate enactments for that. These are, I think, some of the changes which came to my mind and I thought I must share with you, which were beyond what Mr. Vikramjit Sen and Mr. Banerjee and Mr. Acharya said. Thank you very much for giving me this opportunity. Thank you.
Thank you very much.